way that has the appearance of objectivity, and if you subdivide so as to pulverize the reasoning, it is difficult to spot the exact point where you use discretion. So you pretend it's all a matter of technicality. I just, create this perfect machine to decide what's necessary. I'm sorry if you win or lose, it's not me, it's the necessity test. And we know that this is very important because in the international law, we don't have state authority from the above, and more or less, judicial branch is an expression of state authority. They can do whatever they want. Roughly, I know, in international law, it's all based on state consent. So the idea is that judges are not real judges, are not real state authorities. They are sort of arbiters put there to enforce contracts between states. It's very simplistic, but this is the paradigm of state consent. So whatever judges, judicial subjects do, is liable to be criticized for not enforcing the contract. So pretending that they're just setting up a very technical machine to decide cases where the expenditure of discretion is pretty much at the forefront, you try to circumvent the risk of exposing your discretion. So back to the underlying question, sources of law. So what are the connections between judicial tests and sources of law? Of course, it's not provision, black letter law. So are they similar to soft law? Well, not really. Soft law usually is adopted by the same subjects who would be able to adopt normal law, but they know it's not going to work, and then it's not binding. Whereas in this case, judicial tests are count in a reasoning of a binding decision. Not very convincing. So what judicial tests look like is they look like interpretative declarations or unilateral declarations. So instances of legislative nature whereby the parties or the legislator takes action to clarify another norm, or a unilateral declaration whereby a party to a treaty puts a declaration saying, by necessity I mean this and this, mind you. The rule is similar, except in this case, it's not the legislative body who does this sort of clarification task, but it's the judicial body. And clarification of provisions by the judicial body beyond the mere, interpretation of legislation idea is quite common in international law when we realize that treaties are by definition incomplete because states know that negotiating, especially in multilateral treaties, negotiating in detail is very difficult, and because states have read Aquinas' Summa Theologica and they know that up to the very last detail, as we learned yesterday, you get in trouble. So they deliberately entrust a third-party adjudicator to fill the gaps of the contract at a later point in time. Following the principles, following legal hermeneutics, they know that the contract is incomplete when they sign it. And this is what, and this is what judicial tests seem to do, filling the gaps of a deliberately incomplete contract. And now there's this bit in Italian, I don't know exactly why, we'll skip it. And so what are the classic sources of international law again? This is the classic list. You find it in the Statute of the International Court of Justice, and the only reason I have it there, because you can now try to fit, we can now try to fit judicial tests somewhere over there, and I don't think it's a useful task, but at least we can say that judicial tests have an element pretty much of each of the classic sources of international law. So when we talk about conventions and custom, the first two listed items there listed, well, we said the judicial tests build on a norm that is there. So number 1 and 2 are necessary for a judicial test to arise. General principles, well, again, we know that judicial tests, at least majority of times, they are there precisely because they want to put into practice a general principle. And the judicial decision and teaching of the qualified writers, which is a supplementary means of interpretation, well, this supplementary means of interpretation of international law is there because it's premised on the authority of these elements, judicial decisions and teaching. And the same goes with judicial tests. The reason why they're sticking is because they are authoritative, because people rely on the reasoning that is encapsulated in these two paragraphs. So, at the crossroads of all the sources of international law, we find these judicial tests that are perpetuated without a formal reason, and they are accepted without a formal reason. So, my conclusion, very tentative, is that we don't need exactly to conceive judicial tests as an independent and discrete source of law, although we have to be aware that they are not. And that means that what they are is, well, first of all, standardized bits of reasoning repeated for the sake of convenience, to save time. But since they're not source of law and we have no formal precedent, and mind you, I know it's the worst kept secret in international law. There is a system of precedents. But it's not there formally. So we shouldn't be so yielding and accept that judicial tests, which are just reasoning repeated all the time, are binding. So first consequence of this excursus would be, first of all, internal questionability in a case. Maybe it's worth trying to challenge that test. That test is nothing else by a shortcut for the judge not to run over what's necessity over time. But you might argue that necessity is not that thing. And that might be worth questioning the judicial test because there's no precedent. On the other hand, external applicability, since we know what they are shortcut, they are an effective way of catching complex reasoning depending on similar principles, well, then they should be used more or less if you think they're convincing, regardless of the system. So if the principle of necessity of the WTO is pretty convincing, you use it in the ECHR assessment of proportionality, because all you do basically is to struggle with the principle of necessity, which is, as a principle, it is the same. The application is different in every system, but the reasoning might be similar. And if necessity is an easy case, because pretty much every system has developed its own necessity test and strict test of proportionality, whatever. There are other cases where these judicial tests are really easy to import because, you know, they operate at this abstract level of principles, and they might be worth taking a look at, even if you're not in the system of origin where they were formulated at the beginning. And I believe this is the end. Thank you very much for your attention.
Thank you, Filippo. Questions?
I would have one if nobody else to some extent I agree with you, because there is a problem, there could be a problem with this kind of tests as long as they are not applied consistently. And so, in my opinion, they are mostly part of case law, and they should be backed by precedents. But not only, and I guess in all systems of law we have some kind of precedent principles. Like if we don't have a stare decisis system, we have a system of established case law. So we can trace through the reasoning of judges how they applied a particular precedent. So, okay, they are problematic because they are not, so to say, part, not so directly part of general legal acts, but through case law we can check whether they were applied consistently. What would be your opinion?
what I believe is that in this particular instance, even if it were consistent, we would have a problem. Obviously, we have to be reasonable, and we know that a consistent case law is that it's difficult to overrule. And you might as well, if you're a reasonable actor, rely on the test than try to challenge it. But that is an evaluation of cost-benefit. It's not something that has to do with the legal nature of the test. The test is not a source of law, and you know it's an uphill battle to struggle against the text in the next case, but still it's not really clear, but it should be taken as is and put there and impose its own authority on the next case, where it purports to apply some rules that are written differently and in a far less sophisticated detail. So obviously consistency helps, and we have the other problem that you mentioned, that sometimes tests are not there, and that is a problem in itself, and sometimes tests are there and they're not used consistently. So the paradox is sometimes the tests are so much solidified and stonified and not flexible because they're used as a contract, that they suffer from the same problems that provisions suffer from, inconsistent application. And at some point you would require a meta-test to make sure that the test is applicable in a consistent way. So it's not really a way out. It has reductible legitimacy in the way it emerges. And usually it's tolerated because, I think, because the mindset of every lawyer is so much mindful of its own legal system where precedents are accepted, that they believe it's reasonable, of course, and okay to have precedents even in international law, where it shouldn't exactly be the case.
Further questions?
When you presented your first example of judicial test, that is the attribution of responsibilities to states for non-state agents,
Yeah.
It reminded me of the rule about responsibility of parents for what children do because they have sort of control over children, and also responsibility for what animals do. If I have a dog and I have control of it, etc. So in that sense, maybe one could wonder about the reason of this test in terms of analogical reasoning. Saying, well, there's an analogy between being a non-state agent under the control of the state and being a dog under the right. So there's an analogy on that, and since we have a traditional rule on that, we can extend the ruling to these cases. And to put the point in more general terms, the question would be, what are the basic justificatory patterns for using a certain test? When it is introduced, not when it is repeated in a sort of stupid way, but when it is for the first time introduced, I guess there are some reasons and some arguments supporting it. So are there any patterns of
that's an interesting point. So this test, as you say, comes from the general principle that is common to every legal system, whereby if you have authority over a subject, you might be held accountable for whatever he does. And that's why we have this custom. It's not written anywhere. Now it is written in the articles, but that was 2001. It's not written anywhere, but it's a general principle of common to all nations. The problem that we had there is that the court decided to apply effective and direct control and instructions, rather than a parent is probably responsible even if he didn't instruct the child to do something wrong, just because he has overall control on it. And in fact, on the very same fact of the conduct of paramilitary forces in Bosnia, being or not able to trigger Serbia state responsibility, the Court of Justice said, sorry, no, because we cannot find evidence of direct control. Whereas the ICTY, International Criminal Tribunal for former Yugoslavia, thought exactly the opposite, applying overall control. We know that contact between Serbian authorities and the paramilitary forces was enough, intense enough, to justify overall control and the assumption of responsibility, regardless of the direct instructions. So we have a general principle that we all know about, and then we have a judicial test that tries to put that principle into detail, but it can go into different directions. And in this case, we don't know whether paramilitary forces were acting on behalf of Serbia. The first time around, as you notice, and I try to draw attention to, is weird that they have to resort to general wording. Why should they? So you know that they are trying to prepare the future case law, so they have a normative intent. I just phrase it in a general enough wording that it looks like a norm, rather than the reasoning of the decision. And the second is, I step back from the specifics of the case to avoid the accusation of being activist and to choosing what I like more. I try to take the wrong turn and try to go back to principles and explain that by necessity this principle applies in this way. So I think that without bad faith, it's actually in itself, it's a good way to have reasoning that is not oracular or really, really synthetic and ambiguous, but relies on, at every step, you expose the general principles behind the reasoning. But since then we know that this is repeated and this is not necessary, it's slightly suspicious.
Any other questions? All right. Oh, yeah. Yeah.
Just a comment. Your conclusion you reach is that there are not resources alone. No? Maybe that's true, taking from the point of this formalistic sources of law. But then if you take more wide, broader definition of sources of law, not based on Article 38 of the Statute of Justice, one could argue that they are. And in my mind, your presentation, from your presentation basically derives that they are sources of law. Take, for example, principle of necessary democratic society, the European Court of Human Rights. This is a principle which is applied in each and every case before the court. In any way, in the de facto, it is a source of law. But then, of course, if you ask traditional lawyers, they will say no, it's not.
I tell you why I think it's still worth not considering it a source of law. Well, first of all, when you have a principle, it's not artificial to keep the distinction between the principle, which is a source of law, and the test or the application that is formed throughout the case law, which is not a source of law. It's just the application of the principle. I think this distinction is still tenable, and the consequence, as I said, is that next time around you might as well try to challenge how the European Court of Human Rights interpret necessary for a democratic system without relying on the superfetation of this test that has been formed in 20 years. Because it might be questionable in a single instance, or it might be a product of layers of reasoning, each one trying to adjust the deficiencies of the previous one, and then you come up with this long test for the word necessity. So, do we really have to rely on that necessity test as part of the WTO agreement? Or are we able to say, you know, I committed 60 years ago to this word necessity. I don't want to necessarily to be bound by this new test that's been created out of nothing. And the other thing is that if you consider tests for what they are, so some sort of shortcut of the reasoning, well, the shortcut of the reasoning separated from the norm is not necessarily something that might function only within the system where the norm is. You can take the shortcut of the reasoning and try it somewhere else. So it facilitates transplants in a sensible way, because of what you get there is the product of years of application of proportionality, and that is what, for instance, the Mercosur Tribunal did it with proportionality. They said, Why should we try to reinvent the wheel? There's the Court of Justice that done it for 60 years, and they took the proportionality test and they put it there. We all know that it's liable to provoke some inappropriate result, and you have to be careful in doing so, whatever. The thing is, we are applying the principle is abstract, and it's general, and it's universal, of proportionality. We might as well take a look around. If we consider it a real source of EU law, that would not be that much legitimate. Thank you.
Okay, thank you very much. Now I'd like to invite our next speaker,
Okay.
Lucescu, who's going to talk about natural and positive law in transitional justice.
Thank you very much for inviting me here. So, as I was presenting, I'm a political scientist, so I would very much like your feedback about what I'm doing, because you are coming from different schools. Okay, so in my presentation, I will analyze the way in which various post-dictatorial societies designed judicial accountability for past human rights abuses, trying to reconcile law as written and law as right, procedural and substantive justice. And based on various examples from different geographical area and periods of time, I will reflect upon transitional justice as a mediating concept that seeks to mitigate the autonomies of positivism and natural law during periods of political transformation. I will refer here mainly to domestic accountability and not to international tribunals, although I will make some references to the Nuremberg trials. So I will start by saying that while in democracy the rule of law is understood as adherence to known, stable and regular norms, transitions from dictatorial regimes produce rule of law dilemma, especially in politically controversial areas where the value of legal change is in tension with the value of adherence to the settled legal precedent. And this dilemma appears in the whole transformative process of the legal order, but especially when states have to deal with accountability for past human rights violations committed by the former regime. And since the end of World War II, there were many cases of post-dictatorial transitions where there was a conflict between the desire for procedural justice and the desire for substantive justice, the desire to restore belief in procedure and to demarcate oneself from the practices of the old regime where law and judiciary were used in political purposes, and the desire to sanction that regime as severely as it deserves. And well, this conflict appears in several situations, like for example where amnesty were adopted just before the regime changed in order to prevent future prosecutions, where statutes of limitations for the crimes committed expired. I'm referring here mainly to long dictatorial regimes, like the communist one, where the crimes were committed at the beginning of the regime. Or for example, where national criminal codes of the dictatorial regime were not defining and punishing the types of crimes committed. And here there are two cases where these crimes were already defined in international law and where these crimes appear to be like new yet undefined types of crimes. So transitional societies solved this dilemma in three different ways. And the first one was to insist on the respect of basic legal principles, such as to forbid retroactive laws, to forbid the cancel of the amnesty, or to forbid the extensions of status of limitation. There are in fact very few cases where things happened really like this, and I will mention post-communist Germany, starting with 1992, where the GDR law was applied, and then civil society said we wanted justice, but we got the rule of law. The second example is the refusal of the Hungarian constitutional court, post-communist constitutional court, to extend the status of limitation for crimes committed during the communist regime. In 1991, the court struck down a law adopted by the parliament in this sense, arguing that such a measure would mean to compromise the principle of predictability and foreseeability of law. Well, the second solution was, in fact, that the new regimes can frankly and openly accept the need to violate these principles of in an unprecedented situation. And for example, in Denmark, after 1945, and in Holland also, explicit retroactive law were adopted in order to punish crimes committed during the war. And this was probably facilitated by the fact that in the constitution of the countries there was no ban on retroactivity. So the same things happened in Hungary, for example, where in 1945 a law stated that criminals could be indicted even if at that time they committed the crime, their actions were not liable to prosecution. And in France in 1964 the criminal code was modified. And it was modified, France introduced crimes against humanity and also stated that these crimes were punishable no matter when they were committed. And in fact, several trials started in the 70s, and for example in 87, Klaus Barbie was convicted on the ground on this retroactive law. Also, the 1968 Convention on the non-applicability of statutory limitations for war crimes and crimes against humanity states that these crimes are punishable no matter when they were committed. In fact, the conflict between these two approaches was at the core of the debates regarding the prosecution of Nazi crimes in federal Germany in the 50s. So the central issue for the post-war German court was whether to accept defenses that relied on Nazi law, and the problem is very well reflected in the famous debate between Fuller and Hart. So for Hart, prior written law, even when immoral, should retain legal force and be allowed by the successor courts until it is replaced. So the full continuity with the prior regime is justified by the need to restore belief in procedural regularity, and response to past tyranny has to stay in politics and not in justice. This was Hart's vision, which in fact this is how German courts decided to judge upon the Nazi law. And in opposition, well, Fuller said that as the Nazi law was immoral, so it is not to be taken into account. And he claimed for legal discontinuity justified by the evil nature of the prior regime. And also another legal philosopher, Gustav Redbruck, argued that in circumstances where a conflict existed between the codified law and the higher conception of justice, and where the contradiction between the two assumed an intolerable dimension, it is not only suitable but imperative that the codified law be declared unjust and subordinated to the cause of morality. In fact, this vision, stated as such, was used in Germany in 1990 by the judge who who sentenced the first trial against border guards from the Berlin Wall. So the judge acted as if the existence or non-existence of previous precedents was irrelevant to the case, for the case. So the real issue was what kind of state the GDR was. And explicitly citing Redbruck principles, the judge emphasized that one would not respect the laws of GDR, as GDR was a illegitimate regime. As the legal standards of GDR stood in cross contradiction to the generally recognized foundations of the rule of law, the border guards should not have obeyed to such law and orders. Later, in 1991, the sentence was struck down by the appeal court, who preferred to apply positivist vision, and this is how the crimes committed in Eastern Germany started to be convicted. So struggling with this dilemma, most of transitional justice processes adopted a third way, where one can create alternative constructions, generally by using subterfuge in an extensive, although sometimes problematic interpretation of the judicial norms in force at the time where crimes were committed. And here, we can identify three